Hello, everybody. Good morning. Welcome to my next live. So, what are we going to talk about today? Well, I thought I would give the lowdown, the description, some specifics on the TN visas, since I'm sitting in America and up north is Canada and up south is Mexico, down south, sorry. And the TN visa is specific to those countries. And there's a lot of issues with the TN. So what I'll do is I will review with you the specifics and some generalities and so forth on what the TN visa is, how it works and so forth, and go through my normal spiel on that. And then afterwards, I'll be happy to answer your questions. So what you can do is ask whatever questions you want. I won't answer it right away. What I'll do is when I'm done talking about the TN visa, I'll scroll back up through all of the people joining. I'll look for the questions, and then I will come back and go from there. Okay? So let's start with the TN visa. What is it? Okay, well, it's referred to as Treaty NAFTA visa. Okay? And basically, if you're a Canadian citizen or a Mexican citizen, you can apply, if you qualify, for the TN visa. So there's actually a lot of people from different countries, and I can think like a lot of them are nurses actually, and it's too hard, too long to get into the United States. So what they do is they immigrate to Canada, they ultimately become a citizen, and then they can come into the U.S. on a TN visa. So just because you might not be born in Canada doesn't mean the TN visa is out of your reach, okay? If for whatever reason you can't get into the U.S. for many years, like let's say, for example, you are a very qualified engineer. I'm just using an example. And you're from India, and you ultimately want the green card. Well, if you're from India and you have all this education, you know that there's a lot of other people that are also immigrating to the U.S. and that they have to wait years, sometimes over a decade, to be able to come here. So some find it more beneficial to immigrate to Canada. And I'm not a Canadian immigration lawyer, but I do understand it's a lot easier and quicker. You immigrate to Canada, you get a nice job there, you're working there for a while, and ultimately you become a citizen, and then boom, you can come here as a on a TN, okay? So there are ways of doing it. So first of all, what is the TN visa? Well, it's not the green card, okay? It's a work permit. It's a work permit, which means that with the TN, you're going to eventually have to go back to Canada or to Mexico, okay? Depending whichever you're a citizen of. I've never found or had a client that's both a citizen of Canada or Mexico at the same time. But if you're a citizen of either one, you can apply. But again, you have to have what's called non-immigrant intent. So I have a lot of people that say, okay, well, what if I get the H-1B? Can I do an H-1B instead of a TN? And the answer is yes, except there's a few things you need to be concerned about. First of all, H-1B, specialty occupation visa, is for people essentially who have degrees and who are going to be petitioned by a company here in the U.S. Now, with the H-1B, there's only so many per year. It is very difficult to get, not so much because you might not qualify, but because it's only open a certain part of the year. And I'm telling you, and I'm not kidding, it's like horses running around the track. When it opens, there's like 300,000 applications that go in, and there's less than 60,000 that get selected. Now, if you have a master's degree, there's another 20,000, but we're talking, a week or 2 weeks or a month at most, and they're all gone for the rest of the year. So that's why, if you are a Canadian or Mexican citizen, a TN is an ideal alternative to the H-1B. Because more or less, there's obviously variations, but more or less, if you have a college degree and you're in the list of available positions with the TN, which that comes in a appendix actually that lists all the various ways you can do it, then there's no limitation on the number of TNs issued per year. There's no limitation on the number of renewals you can get on a TN. And there's no limitation on coming in and out of the US with a TN. So you might be asking, okay, well, if you're a Canadian citizen, why on earth would you get, and you can get an H-1B, why on earth would you instead of a TN? Well, there's only one reason, to be honest with you. And that's because H-1Bs have what's called dual intent, okay? That's in your mind, dual intent. That means that you can both work here as a non-immigrant on a work visa and apply for the green card at the same time, okay? That's why you'd want the H-1B instead of the TN. Because when you're on a TN, you always have to prove non-immigrant intent. It does not have dual intent. So if you apply for the green card on a TN, you're going to be out of luck the next time you want to renew it, because they're going to say, no, you don't want to stay here, or you don't want to go back to your home country. You're lying. You applied for the green card. You want to stay here permanently. So you can't have dual intent with a TN. So when people tell me, which to be honest with you, most people who come here want the green card, that eventually they want the green card, it's a matter of timing, okay? So you come here on the TN, and usually the TN's issued for about 3 years. So if you time it right, you can come here on the TN and then turn right around, assuming you change your mind and then want to get the green card, you can turn right around and start applying for the perm, then the I-140, then the adjustment of status, and you're cutting it close, with the 3 years you have left, but it's certainly doable if it's done right, okay? And like I was talking about earlier, if you come from India originally and you're doing the perm and all that stuff, you're going to be waiting a decade, 12 years, 15 years, but from Canada, the backlog is much, much shorter, if at all, okay, for employment-based petitions. So you can time it right, get on the TN, and turn right around and apply for the green card. Now, if you can't, well, then, you still have to time it right. You're not going to be able to renew a TN realistically if you've already applied for the perm or the green card. Okay, so that's that. So when you're on the TN, a lot of people say, well, okay, what qualifications? What do I need? Okay, can I get a TN if I want to be a cashier? Well, the answer is no. A TN, like an H-1B, is for people who are very qualified. Okay, who have degrees for the most part. Now that doesn't mean every TN requires a degree. Some require what would be referred to as just certification. Okay, some require certain years of experience. Some require degree and certification. So it's in an appendix called 1603.04, and it lists all the various, occupations, engineers, accountants, analysts, and so forth. And what happens a lot of times is people will look at that and they'll go, well, mine doesn't fit squarely in any of them, so guess I can't get a TN, goodbye. It doesn't work like that, okay? Especially as an attorney. We live in the gray lines. That's what we do, okay? If it's black or if it's white, generally you don't need a lawyer to help you, okay? Because it's just click the box and boom, you're in. But, especially with immigration law, it's not just black and white, okay? The vast majority of immigration law is in the gray area, which brings me to a little point here. I have some people say, well, do you guarantee me success? And I say, well, first of all, no. Any lawyer who guarantees you success, you need to say goodbye, turn around, and walk out the door, because they can't legally do that. Okay, but secondly, the reason you want a lawyer who's an expert in what they do is because they can't guarantee you success, and you have a lot better chance of success if it's done properly, if it's argued properly, and so forth. So if you don't fall within one of the specified areas exactly of the TN occupations, what I do is I analyze and I say, okay, well, which one are you closest to? Which ones might you be? Okay, and there's also sort of the catch-all. And we make the argument that that's why you should be granted the TN because of this and that reason. We put all the legal arguments in there, and hopefully it works. Okay. Obviously, we would never submit anything that has no chance of working, but again, if it's in the gray area, you don't know. So you have to make the best argument you can. So some people then also ask, what's the difference between if you're in Canada or if you're in Mexico? Okay. Is TN the same? Well, it's basically the same. Okay. I mean, the occupations are the same. There's not different occupations you can qualify if you're in Canada versus Mexico. But what is different is how to get the TN. Okay. Without doubt, if you're a Canadian citizen, it's easier to get a TN. I mean, without doubt. Let's say that you have a person that is exactly qualified, okay? But let's say one's a Mexican citizen and one's a Canadian citizen. And nothing else differs except their citizenship. Well, with Canada, with a TN, if everything's prepared properly, they can literally go to the port of entry, present the TN application, and if it's approved, boom, walk in. I mean, it can all happen in one afternoon, okay? It's quite easy. I mean, not quite easy to get the TN because it still has to be prepared. You can't, like, for example, walk in with a, paper saying, this person's going to work as an engineer. Thank you. Please let him in as a TN. I mean, obviously, you need a lot more than that. But in Mexico, you can't do that. You have to pre-schedule an appointment at the consulate. It has to go through the normal consulate interview and so forth. So it's much more lengthy as to how you can get it and so forth. Why they do that, who knows? But that's the law. Okay, so given that, whenever you're doing the TN visa, one of the major reasons in Canada or Mexico they're turned around is because they didn't properly prepare it. The employment letter isn't sufficient enough. They're not within one of the, elements or items within the appendix to get a TN. They haven't properly proven what they need to prove, okay? You can't just think because you're a Canadian citizen or because you're a Mexican citizen that you can just jump right in and get a TN without, doing anything else. It has to be prepared properly. When my firm does the TN, we do the attorney cover letter, we do the supporting employment letter for review, revision, and ultimately attachment, the exhibits, affidavits, evidence, we tab it and everything else. I mean, it's a real pretty petition, okay? But that's how everything does when it comes out of my office, all right? So you need to make sure it's prepared properly, okay? And then you can hop on in, get the TN, and go from there. So hopefully I have sufficiently explained so you're, in a better position to know what to do, how to do it, and when to do it. Okay? So given that, I'm going to scroll to the beginning here, and I'm gonna let you know what the answers to your questions. So let me just scroll back here. And as I always tell you, this takes me a while because I got to scroll for a while. But I'm going to scroll. And I also, at this point, say, how is everybody doing? It's hump day, Wednesday. Yay. So let me go through here and just see if there's any specific questions. 1 second. Sometimes I scroll and it goes up like 100. I have to re-scroll back. Okay, 1 second. Okay. I figure it's better to scroll and make sure I get all the questions and take a moment than to just rush through and miss some questions. So be patient. It'll just take I just got to scroll through this just to make sure. Just a minute. Okay, I'm getting to it. By the way, for anybody who's wondering, to become a lawyer, it's a bachelor's degree. And my bachelor's degree was in business, and it's a law degree. So for me, that was 7.5 years. Then you take the bar exam, and to become a certified specialist in immigration law, which I am. You practice for at least 5 years, and you have all kinds of requirements and cases and so forth. Okay, let's see. It's kind of funny. I got a very nasty comment from somebody that nobody cares about this. And here he is giving a nasty comment that nobody cares, yet he's sitting there watching what I'm saying. It's funny. Okay, just a second. Okay, does the first DUI affect your EB3 process? Well, it might. Okay. First of all, whether you say first or second, obviously, if you have more than one DUI, it affects you more. But the DUIs depend where you are in regards to it, okay? Like, for example, a DUI in California, because of the statutory language of how it's written, it's from a legal standpoint, it's easier to get around the inadmissibility issues than in other areas. Like, for example, if you're in the Fifth Circuit, and sometimes it's not referred to as a DUI there, it's referred to as a DWI, but there are other statutory elements of it which make it much more difficult to get around the admissibility issue. So I can't just tell you yes or no as to whether or not that affects you. What I would tell you is, the EB3 process, that's an employment-based third preference petition process, that there are certain parts of it that it doesn't matter how you're admissible or inadmissible, because it doesn't deal with that. It deals with other things. Like, for example, the first part of the EB3 process is called PERM. And PERM is where the bottom line, there's all kinds of stuff you have to do, but the bottom line with PERM is the employer is showing there's no available U.S. workers for the position. That's the bottom line, okay? That has nothing to do whether you're admissible or inadmissible. DUI has zero effect on that. The second process for the EB3 process is the I-140 petition. And the bottom line there, I'm simplifying it, but the bottom line there is that the employer is showing that you, the future employee, are qualified for the position. Again, nothing to do with the DUI. You could have 10 DUIs. It wouldn't affect the approval. So you could have an approval of the PERM and the I-140, and the DUI would not affect it. So first, what I'm telling you, I don't know where you are in the EB3 process, but don't stop it because you have a DUI. It's only the third process that comes in effect. Okay, that's where if you're outside the country and you're doing consulate processing, and obviously you have a DUI, so I suspect you're inside the country and you're probably here on a work visa, that's when you're going to adjust status. And that's where you're going to have to, of course, disclose all of the criminal history and so forth. So that's where it will come up whether or not it will affect your ability to adjust status. Now, as an immigration attorney, first of all, I would analyze the statutory language of it. I would determine whether it makes you inadmissible. If it does, then I would make it so that you, first I would argue if it doesn't make you inadmissible, why legally, and that no waiver is needed. But if it does make you inadmissible, then I would need to tell you that we need to prepare a waiver in order to, and see if you qualify in order to go forward. The fact you're doing an employment-based petition probably means, and clearly means, you're not married to a U.S. citizen or lawful permanent resident, and you don't have a family-based petition to go on, which means that a waiver is probably not available to you if you need one. So, given I've said that, if you are still in the criminal proceedings, then don't plead guilty to this. First of all, get an immigration attorney to advise on what you should do. Because when I do this and I do a criminal evaluation, I work with the criminal attorneys, and they may be experts at criminal law, but they know nothing about immigration law. And one little difference could make all the difference in your status. They may think they're giving you a good deal, but it may make you inadmissible, whereas something they may think is not such a good deal doesn't have any effect on your immigration. And that bottom line, that's what's going to be more important. Okay? So, long answer to a question, but that's how it is. Now, the next question, do you practice criminal and immigration law in Texas? And the answer is yes and no. Okay? This goes to what I was just saying on this other one. Immigration law and criminal law are integrally related, okay? And if you want the legal term for it, it's called cremation, okay? So yes, I do a lot of cremation. But immigration law is federal law. So I practice all over. I have lots of clients in Texas, okay? But criminal law specifically is state law. Unless, of course, you're being charged federally, in which case it's federal law, but it's still federal law under Texas, if you happen to be there. So what that means is that if you have a crime that you've committed, for example, and you're in criminal court in Texas, yes, I can help. And yes, it's very important because whatever you happen to be in court for most likely will affect your immigration status. And it's particular to each client. Okay, so what I do, again, is a criminal evaluation. I work specifically with your criminal attorney. And the criminal attorney and myself, I see everything that's on the table. I look at your history and so forth. And the criminal attorney, for example, after I reviewed everything, will say, okay, I got a great deal for this client. We can plead to, assault with a year in prison rather than, going to trial and possibly getting 12 years. It's a fantastic deal. I want him to take it. What do you think? Well, I can tell you right off the bat that I would tell that criminal attorney, no, do not do that. Do not do that. Because if you do that, then that person's going to be an aggravated felon. And even though they get a year, even if it's a suspended sentence, even if they don't spend a day in jail, they're going to be an aggravated felon. They'll be transferred to immigration detention. They'll be deported for the rest of their lives without coming back. I'll tell you what you can do in that case. I'm just giving you an example. I'd say to the criminal attorney, I go, instead of giving or agreeing to a year in sentence, do 364 days. Okay? And I know the criminal attorney's going, it's only a day difference. What difference does it make? Well, as an immigration attorney, I would say, and cite all the law to the criminal attorney and go, look, with a sentence of under a year, which 364 days is, that would mean that you would qualify for all kinds of immigration waivers. You still might end up in removal proceedings. You still might end up with them trying to deport you, but at least you wouldn't be an aggravated felon. At least you'd qualify for waivers. At least you'd qualify for adjustment or whatever else you might be, however else you got the green card. And that one day will make all the difference in your life. Why? Because you had an immigration attorney work with the criminal attorney in order to make sure you did not go down the wrong road. Okay? World of difference. Okay, so hopefully that makes sense. All right, let's see here. Was all that necessary? I think you're referring to the TN. And keep in mind when I'm doing these lives, I'm abbreviating a lot of stuff, okay? Giving you a good general idea of what needs to be done, but more or less what I went over is what's required. But again, if you're a painter and you're doing a painting, you can do a pretty painting or you can do a really good painting. It all depends how you do it. So it's the same type of thing, okay? So while I'm giving you the generalities, there's a difference between giving you the generalities and having a really good petition in your hand when you walk to the border if you're Canadian and so forth, okay? All right, let's see. Hi, Islamabad U.S. Embassy transferred my case to Doha. Do you know why they transferred the case? No, I don't know why, without first knowing the facts of your case. I see your next question is, your case is administrative processing. That's not a good thing. Okay, that's not good. I sometimes refer to administrative processing as the black hole. Okay, because once it goes there, a lot of times it stays there forever. And once it stays there forever, I have to do things to give them leverage and motivation to get it out of there. So I can tell you most of the time the reason things are transferred is because there's an issue which is not in your favor. They might have seen something that, you might have committed fraud. They might have seen some criminal history you didn't disclose. They might have seen the employer who might have petitioned you might be on some watch list for submitting fraudulent petitions. Whatever it is, there's something that has flagged them to transfer the case. Okay. And I'm assuming since you asked me, you didn't particularly or individually require it to be transferred or ask for it to be transferred. So they're transferring it for some reason, and the administrative processing, the black hole, means that something has been flagged. So in cases like this, what I do is I wait a sufficient time, and then I send in a formal inquiry. And then when they don't answer, or they say, again, it's administrative processing, which doesn't say anything, I can prepare for the client a writ of mandate, or writ of mandamus, which is a lawsuit in federal court, which, basically says, look, this administrative agency has a duty to adjudicate my case. It doesn't say they have a duty to say yes, okay? It says they have a duty to adjudicate it, so it might end up being a no. So I'd never do a writ of mandate if I review the case and there's a decent chance of denial. Okay, that would be silly, because all you're doing is you're forcing them to say no. But at least if it's there forever and you have a good case and there's no reason, like let's say your name has popped up on some list and nothing else. I've had that happen. Okay, it depends what country you're from, but I've literally had that happen where the name pops up on some watch list, and even though it's not your name, it's similar, and they think they're going to put it in administrative processing for 2 years while they make sure. So I do the writ of mandate. It forces them to get it out, and then we proceed from there. Okay. All right. Conviction of possession controlled substance from 2013. Can you help vacate that in Texas? Again, that goes back to I think you're the same user that asked the question. I mean, that goes back to what is the possession and so forth. I mean, for example, if you have possession of marijuana for less than 35 grams, there's an immigration waiver for that. There's no need to get that waived. If you already have a green card and you're in removal proceedings, possession by itself doesn't make you an aggravated felon, and you can do cancellation of removal if you qualify. Okay, so it might not be necessary to go to court. It depends on your case. So give my office a call. Okay. What about probation? Does that count as a sentence? Well, you can't get probation unless you have a conviction. Okay, one goes with the other. So the sentence, if all you got was probation, then the sentence would be, no jail time and 3 years probation. I mean, so yes, it could count as part of the sentence. It depends. Okay, again, I'd have to see. You skipped a question before the conviction question. Well, sorry. I try as best I can not to do that, but there's a lot of stuff I have to scroll through. All right. Well, I think that's going to do it for the live today. I hope everybody has enjoyed, learned something or two. I do 1 or 2 lives a week, depending, and then all my other stuff. So if you want a consultation, again, there's lots of different ways to get that with my office, and we go from there. Okay, so I hope everybody has a great rest of the day, and I'm going to go bouldering this afternoon. It's fun. All right, so everybody enjoy the rest of your day. Until the next live, goodbye.